Our next speaker this afternoon is going to be Ashley Deeks. Rest, folks. Thank you. Our next speaker this afternoon is going to be Ashley Deeks. Now, one of the ways in which we were trying to determine whether there was this fundamental shift occurring in the way in which the law of armed conflict was being interpreted and applied was the way in which various judicial forums was now interpreting the law of armed conflict and applying it to particular conflict scenarios. And Ashley is going to be touching upon that. So, Ashley, over to you.
Thank you very much, David, and of course, thanks to the organizers and to Derek. I'm very happy to be here today. Sorry, I also drew the graveyard shift. I hope you all caffeinated up suitably. So I'll dive right in. As it will be news to no one in this room to hear me refer to the political tension under the Bush administration between the U.S. and European states, particularly in the way that we chose to conceive of and fight conflicts differently during and immediately in the aftermath of September 11th and continuing on in the years since. I think many thought that this tension would effectively dissipate when President Obama came in. They anticipated he would make a number of important policy changes that would mitigate those differences. And in fact, he has made a number of significant changes that affect how we are fighting armed conflicts, particularly the conflict with al-Qaeda. But I want to talk today about something that has been a little bit quieter and also arguably a little bit more permanent that's been happening that I think will continue the divide between the ways in which the two sides of the Atlantic are fighting these conflicts. And these are rule changes coming out as a result of court decisions in our respective judiciaries. So I'm going to argue that the way that the U.S. and European states are fighting, the rules they are bound by, are going to continue to diverge as a result of some of these decisions. And I want to talk today about the ways in which courts have addressed 4 different categories of litigation about war fighting in non-international armed conflicts against non-state actors. And this is litigation being brought first, claiming that individuals are being unlawfully detained. 2, that individuals are claiming that they've been unlawfully treated, particularly during detention. Number 3, that they're claiming they are being unlawfully transferred from one state to another. And 4, they're claiming unlawfulness of particular intelligence activities. And I hope that you'll see as I talk that there are sort of 2 different categories of differences. One is the difference in our court's views on the propriety of reaching the merits of particular issues in these cases, and the other is these different substantive outcomes of the cases that are setting these different rules of the road. And the general trend that I want to highlight is, in fact, that I think the U.S. in general is winning its cases, and European states in particular, I'm going to focus on UK cases, and those cases when they move to the European Court of Human Rights, how the UK is basically losing its cases. And then I want to talk a little bit about the real-world effect of some of these judicial decisions and talk about, I guess, speculate, really. I'd be interested in others' views on the possible causes of these differences and things states might do to mitigate some of the different judgments that we're receiving while respecting the court decisions, of course. Let me just throw down a quick footnote with regard to Lawfare. This obviously is a panel about Lawfare. I am not suggesting that this litigation either is or is not Lawfare. I think Charlie did a good job to point out that that term has somehow been hijacked, and I'm not impugning the motives of individuals who are bringing these cases, but I do think it's relevant in this panel because I think the cases, as we will see, are having a pretty systematic effect on the way in which we're fighting conflicts, and so it seems like this is an appropriate forum in which to talk through some of these cases and their outcomes. So let me run through the 4 different categories of cases, and I'll skip through a number of cases, sometimes just naming them for purposes of speed, since we are getting towards the end of our day. The first category of cases are cases about unlawful detention, and here I should say that the Guantanamo cases are a little bit sui generis and don't fit perfectly into my thesis, so I'll start with those. And in terms of litigation against the U.S. government claiming that individuals have been lawfully detained. I think it's useful to break down those cases into a couple of subcategories. The first is detainees who have challenged the executive branch's sheer authority to detain individuals who are members of al-Qaeda, the Taliban, under the laws of war. And there, our Supreme Court has effectively upheld that in cases such as Hamdi and implicitly in Hamdan. So the U.S. has won that broader set of cases about general authority. Then, of course, detainees have brought cases seeking to have federal courts, not just the executive branch, review the legality of their detention. And there, the courts have concluded that the courts do, in fact, have the authority to review their detentions for individuals held at Guantanamo. And then, of course, that was the Boumediene case. Rasool and Boumediene were the series of cases that led to that. Post-Boumediene, the Guantanamo detainees have brought specific cases claiming, as a factual matter, that they should not be detained. And here, Bobby did a nice job talking yesterday at lunch about the outcome of those cases where the U.S. has lost some cases and has won some cases. It's a quickly changing number, so I'm not even going to try to update the win-loss record, but I think it may have changed since yesterday. So, anyway, so there we see a little bit of U.S. winning some, losing some, but the rest of the cases I'm going to talk about in the U.S. anyway, I think you'll see that the U.S. has largely prevailed, and often courts have been reluctant to even reach the merits of the cases themselves. In the wake of Boumediene, obviously, the court left open the question whether U.S. detainees held elsewhere besides Guantanamo were entitled to habeas corpus. And again, as Bobby noted, in May, the D.C. Circuit in the Makala/Makala case said no, courts lack jurisdiction to review the legality of certain Bagram detentions. And indeed, in their opinion, expressed concern about extending the suspension clause extraterritorially to all aliens in any U.S. facility in the world, and emphasized that Bagram was in an active theater of war where there was another sovereign in control of the territory where the detainees were held. The detainees may, of course, try to take this case en banc or potentially seek cert. But for now, I think, and I guess I should also say, you can imagine a factual case that falls between the level of control that the U.S. government has at Guantanamo and the level of control that it has at Bagram. But for now, courts have left it almost entirely up to the U.S. executive to decide if somebody is being held lawfully as a wartime detainee, except at Guantanamo. On the UK side, I think there's a useful case to contrast, and that's the Al-Jeddah case. The facts of that may be well known to some of you. It's about the legality of UK security detention during armed conflict in the territory of another sovereign, that is, in Iraq. The UK argued that a Security Council resolution 1546 had authorized his detention, and that resolution effectively trumped the UK's European Court of Human Rights obligations. The UK House of Lords concluded that the Security Council resolution did in fact authorize his detention, but Article 5 of the European Convention, which governs judicial review of detention, did apply and should not be infringed more than necessary by the Security Council resolution. So here we see a court basically concluding that it had jurisdiction to review Mr. Al-Jeddah's claims and concluding that detention was lawful, but part of the European Convention did apply to that detention. So a difference in scope of judicial review and a difference in applying a substantive human rights piece to the detention. The European Court of Human Rights has just heard the merits of this case, so stay tuned to the outcome, but I guess I would be surprised if it came out in a drastically different place from where the House of Lords came out. So that's the first category of unlawful detention. Second category I want to talk about is unlawful treatment claims. In the U.S., several suspected al-Qaeda and Taliban members have tried to sue U.S. officials for alleged abuse while they've been in U.S. custody. And as far as I'm aware, none of them has succeeded. The two cases that I want to focus on are the Rasool case and the Aurora case. In Rasool, this is former Guantanamo detainees who claimed that they were beaten, forced to be nude, faced death threats while held at Guantanamo. The D.C. Circuit held that the that the defendants in that case were entitled to qualified immunity. That is, that they would not have been expected to know at the time of their actions that the detainees at Guantanamo had constitutional rights. So here we see the court not reaching the merits, the underlying substantive allegations in the case. Aurora is a similar case there. Aurora, I'm sure all of you know who Mr. Aurora is, sued the Attorney General and others claiming a violation of a U.S. statute called the Torture Victims Protection Act, as well as a Fifth Amendment substantive due process claim for removing him to Syria without giving him appropriate process and with the knowledge that the government of Syria would torture him. And the Second Circuit en banc declined to create a new, what we call Bivens remedy, against the officials who are alleged responsible for his transfer. And in deciding that it did not want to create a new remedy for this alleged constitutional violation, focused on the important diplomatic, foreign policy, and intelligence implications of having a court wade into this issue. And so it ended up leaving the task to the executive branch to execute renditions, as it historically has, and to Congress to create a remedy if Congress felt it was appropriate to do so in the face of a possible constitutional violation. So again, we see the courts avoiding the merits of the case. In the UK, there's also been a number of claims, I think, brought with regard to unlawful treatment while a detainee was in custody. I'll just mention the Al-Skani case. An individual was killed while within a UK detention facility in Iraq, and Her Majesty's government conceded that the European Convention on Human Rights applied to the individual while he was in UK custody there. The European Court is also hearing this case. It's consolidated with the Al-Jeddah case, and I just heard it about a week ago. There we can note a difference in government approaches as well as court approaches. The government, in the face of alleged mistreatment, the UK conceded the applicability of human rights type rules, and in the US cases, the US government has contested the application of those rules. So I think we'll see both courts and the executive branches on this set of cases taking a different approach. The third category of cases I'll talk about is unlawful transfers. These are claims by individuals in custody, either by the US or UK, that a transfer of them to another sovereign government's custody would be unlawful. Two US cases I want to mention, the Munaf case and the Kiamba 2 case. In the Munaf case, this is two US Iraqi nationals who sought to block their transfer by the multinational forces Iraq to the Iraqi government for criminal prosecution. It went up to our Supreme Court, which concluded that while the courts had habeas jurisdiction over the individuals, presumably because they were US citizens, the courts were not able to grant a remedy blocking the transfer to the Iraqi government. And the opinion is very attuned to the sovereign rights of the Iraqi government to try alleged criminals or individuals who are alleged to have committed offenses in Iraqi territory. Also considered that they were captured during a non-international armed conflict, and the court noted that it was worried about, quote, unwarranted judicial intrusion, unquote, into the executive's ability to conduct military operations abroad. Kiamba 2, the district court basically picked up the Munaf line of cases. This is detainees at Guantanamo who are challenging their transfers to other countries where the court concluded that no, in fact, the courts were not in a position to interfere with those transfers either to the individuals' homes or to third countries. I would put a footnote, unless, of course, I think there was a patent evidence that the individuals would be tortured if they were sent back and the U.S. tried to transfer them anyway. I think the court would not have tolerance for that. But barring that, did not want to get involved in blocking those transfers, and the Supreme Court has denied cert in this case. So I think we're left basically with a position where courts are not really going to inquire into the legal process or treatment that detainees will face after they're transferred if the executive is comfortable that an individual is not more likely than not to be tortured. Just a quick footnote here, since I'm primarily doing US, UK cases, but Canada, of course, had the Amnesty International case where detainees brought a challenge to their transfer, claiming it violated the Canadian Charter, and the Canadian court, to make a long story short, was similarly skeptical about blocking a transfer of the detainees, at least where there was an agreed framework in place between Canada and the Afghan government. So on the flip side, though, let's look at a European Court of Human Rights case that flowed out of a case brought originally in UK courts. European Court, I think you'll agree, has proven far less deferential to the prerogatives and laws of foreign sovereigns and to diplomatic judgments of foreign ministries, including where European states have sought to transfer detainees picked up in non-international armed conflicts. And here I want to primarily talk about the Al Sadoun case, basically an opposite outcome from Munaf on quite similar facts. Detainees claimed that their transfer to the Iraqis for criminal prosecution would violate the European Convention prohibition on death penalty and on cruel, inhuman, and degrading treatment. The UK court said the transfer of the two detainees to the Iraqi government was not within the jurisdiction of the UK for purposes of application of the European Convention on Human Rights, based on a memorandum of understanding between the UK and the GOI about who maintained legal custody versus physical custody of the detainees. But the European Court disagreed and said, no, in fact, these detainees were within the jurisdiction of the UK for purposes of the ECHR, that the death penalty was basically cruel, inhuman, and degrading, contrary to Article 3, and that the transfer was a violation of the European Convention. And this is despite the fact that Her Majesty's government had argued that it really had no option but to transfer these individuals, that it lacked the authority to hold. This was coming up on the end date of the Security Council resolution's authorization in December of 2008. And the UK government also told the court that seeking death penalty assurances in this case would have hurt bilateral relations and, in fact, just simply wouldn't have worked. And the court effectively said, well, you should have tried, and by the way, you also had no obligation to turn them over to the Iraqis for prosecution. And that statement is really in pretty direct contrast to the way the Supreme Court in Munaf thought about Iraqi sovereignty in that context. So again, we see different substantive outcomes, even where in the UK case the individuals were purely Iraqi nationals, not Iraqi UK nationals. And we also see a willingness to look behind diplomatic decisions by the UK government. There's a pending case about UK transfers in Afghanistan, the Evans case, that is, I think, stay tuned to see how that one comes out. Finally, the fourth category I want to talk about is illegality, alleged illegality in intelligence activities. So these are cases where the heart of the case implicates classified information. It may involve actions by intelligence agencies or involves intelligence relations between states. In the US, I'll talk briefly about the Jeppesen and El Masri cases. These are both related to alleged renditions by the US, where the US government invoked what we call the state secrets privilege on the ground that the litigation at issue may in fact reveal sensitive national security secrets or things that would endanger national security. One of our Court of Appeals agreed to dismiss the case entirely, finding that the very subject matter of the program was secret, and it didn't feel that it was appropriate for it to try to wade into that case. Another Court of Appeals was willing to let the case proceed, and it planned to excise classified/secret information on a sort of item-by-item basis. The U.S. sought to take that decision en banc, and the Ninth Circuit heard it en banc, and the decision is pending there. And the Supreme, if it comes out where the panel itself did, it's conceivable that the Supreme Court could take up a circuit split on this. But each court basically upheld the core of the state secrets privilege, which is that the executive branch can invoke the privilege to avoid revealing information that could harm national security. In the UK, I think that we're seeing the courts be a little bit less sympathetic to the UK's interest in protecting intelligence information. There are three cases here. I will not dwell on all three of them. I'll just mention them all in case you're interested and want to look them up. The first, each one involves Binyam Mohammed, who was a UK resident who spent time at Guantanamo. He had one case in an effort to obtain information that was in control of the UK, but it was U.S. intelligence information, and he wanted that to defend in his own military commission defense. He and some other former Guantanamo detainees brought a civil suit for damages against the UK for its alleged role in their detention at Guantanamo, And the third case is Jeppesen, UK. It's actually a similar case to the Jeppesen data plan case that I just mentioned in the US system. I'll talk mostly, I guess, about the first case. This is his effort to obtain US intelligence information that was in the UK's possession. I'll call it the 7 paragraphs litigation. It's too procedurally complicated to describe. There are about 15 different opinions. But the end result was that the UK courts ordered unredacted 7 paragraphs of an earlier decision that had been redacted that described US intelligence information about Binyam's treatment while he was in detention. The Foreign Ministry had tried to protect that information, and it made what is called public interest immunity. Is that right? PII certificates for the information, explaining the profound damage to the UK national security if that information were revealed, and also talking a fair amount about its effect on intel sharing with the United States. But the courts were ultimately not persuaded by those arguments. The UK assessed that a US decision not to contest Binyam's claims of mistreatment in another detainee's habeas corpus case was basically a concession about mistreatment, and therefore that the information that it sought to reveal already had been made public, so that it saw there was not going to be, in its view, national security damage by ordering the UK to reveal it. I think we see here a court that's more willing to substitute its judgment on national security issues for Her Majesty's governments. And we also see here the use by litigants of one court to obtain information for use in a legal case in another country. We see that also in the Jeppesen litigation. So in conclusion about these cases, I think we're seeing considerably less deference in the UK and European Court of Human Rights courts to executive-type judgments and a broader willingness to take on and decide national security and armed conflict-related issues. Whether this is a trend or a permanent change, it may be too early to tell, but it's certainly something I think we want to keep our eye on. Let me just run through a couple of real-world effects that I could identify of these litigations' wins and losses. In the first category of litigation I talked about, unlawful detention, obviously a direct effect of some of the US cases are that the US has released some of the Guantanamo detainees. A couple more indirect effects. I think first we see courts opining on who the US can detain at Guantanamo, but I would say that the court decisions have forced only limited changes to the definition that the government proffered. Bobby talked about this yesterday. The U.S. has changed its Afghan policy with regard to detention to have the definition of who it could detain basically track the category of people it asserts it can detain at Guantanamo. In the UK, I think after the Al-Jeddah case, we will likely see a push to get very specific Security Council resolutions before conflict, before the next conflict, with the goal of effectively trumping may be the wrong word, but trumping the European Court of Convention on Human Rights. We might start to see an interest in referring specifically to a state's authority to conduct security detention rather than using the broader construct of all necessary measures. And in general, I think it basically requires states parties to consider European Convention provisions when detaining a non-international armed conflict, and on a broader level leads to a more cautious rights-based approach to warfighting. In the treatment cases, I think the U.S. government has won its cases and former U.S. officials have won their cases, so I don't know that there's been much effect in the U.S. as a result of those cases. In the UK, after Al-Skaney, I expect the UK believes that it needs to treat all future detentions in non-international armed conflict or even in peacekeeping operations as covered by the European Convention on Human Rights. It's not clear to me how the UK has actually implemented the Article 5 requirement to the extent that there was some aspect of Article 5 preserved by the House of Lords decision. Does that mean that detainees are ultimately going to need to be brought before civilian judges in war zones? I don't know, and I'd be interested in anyone who has thoughts on that. And it clearly will require independent and impartial investigations of violations in a way that I think traditional military investigations do not necessarily meet that ECHR standard. But the full implications of this, I would submit, are not yet known. In the transfer cases, I think in the U.S., the executive branch has retained significant discretion in transferring detainees to other countries. Canada won its litigation, but its transfers were chilled during the pendency of the case, I believe, and I understand now there's a parliamentary inquiry going on that's quite heated, and I expect that that has led to a fair amount of caution in detention and transfer for the Canadian forces. The UK, it seems pretty clear from the Al Sadoun case that they have to obtain death penalty assurances where that's an available punishment in the receiving state. I think the ability to detain at all becomes harder if you're not allowed to hold unless you can give a civilian judge review to the detention, and you can't transfer. You find yourself in a pretty hard situation. And of course, an inability to detain has a pretty real effect on military operations on the battlefield. In the intelligence activities context, I think the case, the 7 paragraphs case, put real pressure, or may put real pressure on the intelligence sharing between the US and UK. The White House gave a press statement after the UK decision came down and said that the UK judgment, quote, will complicate the confidentiality of our intelligence sharing relationship and will have to factor into our decision making. So I don't know that we'll see a lot of specifics from either government about what that actually means, but it's clear it is factoring in to those exchanges. And I'd also note that all 3 cases in the UK on this topic ultimately flow from UK assistance, from UK assistance to the United States on controversial and sensitive issues. So I wonder whether litigation will effectively heighten the UK's caution in assisting the US government in comparable situations in the future. 3 penumbral effects that I'll mention just before trying to wrap up. I think these cases obviously create precedent for future litigants, and decisions by the European Court of Human Rights create precedent not just for the case, not just for the state implicated in the case, but for all states that are parties to the COE. Also suggests that operating in gray areas may prove less attractive to European states because of this risk of litigation. I don't know if you all remember the famous quote by then the Deputy Director of National Intelligence, Hayden, who said, you know, I want to operate as close as possible to the line. I want to have chalk on my spikes. I think this kind of litigation may send European states in the opposite direction to try to give wide berth to the chalk line. And it's also clear that a change of policy by one coalition partner by virtue of litigation has an effect on other coalition partners and also on states that are involved in those same conflicts. So, for example, if one state partner finds itself unable to detain on the battlefield, it may put greater pressure on other coalition partners to do more of that work, or indeed on the territorial state to do more prosecutions rather than security detentions and so on. One thing that occurred to me in thinking about these cases is what can we point to explain possible divergence that we're seeing in these cases? First thing might be that there's a pretty strong tradition of deference in the U.S. system to the executive and national security areas and in areas of armed conflict. We have doctrines like the political question doctrine, the active state doctrine, the rule of non-inquiry. These are longstanding doctrines in the U.S. system. The UK, I believe, has something called the justiciability doctrine, which I think effectively is intended to do a similar thing, to give a fair amount of deference to the executive on some of these issues. But it seems as if there's maybe a new boldness to take on some of these cases on the merits. And I wonder whether the UK passage of the Human Rights Act in 1998 may have reduced the level of judicial restraint in these areas by providing a new focus on the European Court of Human Rights and its case law, and this lurking knowledge that however you decide at the end of the day, the case may well go to the European Court for additional review. Another area, a related area, is of course the application of human rights treaties to government actions during armed conflict. This is both the question of the extraterritorial application of the ICCPR and lex specialis issues that are too complicated for me to do anything but put a marker down and move on. And then issue 3 is that I think there's a very vibrant national security debate in the United States with voices all over the spectrum. I think we've heard it in this room today. I think we see it in our judiciary. And I have a sense that in the UK there may be slightly less robust voices arguing for strong national security positions, that the civil liberties voices have a very strong foothold there. And I wonder if that creates a different atmosphere in which the judges deciding these cases are operating. So again, I'd be interested in others' reactions to that. I'm good. So I'll just wrap up by mentioning a couple of future steps that we might think about in terms of overcoming some of these sort of lurking and widening divides. One thing that European states could do is they could have their political leadership make national security cases more persuasively to the parliaments, to the public, and to the courts. Where appropriate, it might be useful to have intelligence briefings if it were deemed that that was appropriate and didn't cross the line in terms of separation of powers type concepts. I think it's important to avoid surprises on either side of the Atlantic when new cases or new laws are pending that are going to have a real effect on warfighting. So if the U.S. knows that a big case is about to come down that could really affect how it's fighting conflicts, I think it's very useful to engage with its allies early and often. I think this is already happening a little bit in certain fora, but I think it's important that it be sustained. And then Charlie mentioned COIN a number of times. I wonder whether good compliance with COIN principles actually will help minimize litigation on this front. So for example, the principle of the importance of strengthening host government capacity might lead you to think, well, so let's make sure that Afghanistan has a better functioning prison system, that the guards are well trained, that the facilities are up to at least minimum standards, better law enforcement to prosecute corruption, prosecute detainee mistreatment, and so on. The better those facilities are, the less problematic it may be for coalition states to transfer detainees into those facilities, and so we might see some reduced litigation on that front. Similarly, I think COIN principles basically say, abuses by forces are generally going to come to light. And not only do you lose hearts and minds through those abuses, but of course, those abuses themselves can trigger litigation. So fewer abuses, arguably less litigation. And finally, there's in the COIN manual, it talks about making ex gratia or salacia payments, where that's culturally appropriate to compensate people for their losses. And one question is whether using those increasingly inappropriate ways will help mitigate any of this litigation. And finally, I'd suggest that there could be other non-judicial mechanisms used more broadly for the executive branches to hold themselves accountable that can take better account of operational intelligence realities than courts can, but still avoid the perception of having no oversight of executive authority. And so that might include more robust use of inspectors general who potentially could come in and review a particular situation, maybe recommend compensation where it believes that that would be appropriate, without resorting to courts that then may not have the same sensitivities to intelligence realities and operational activities on the battlefield. So to conclude, I think these cases are having a real impact on fighting. I think the impact is disparate between the United States and European states. I think this is only going to make more complicated coalition fighting, and some of it provides increased disincentives to engage in non-international armed conflicts at all. Not arguing that courts have no role in holding to account executive branches, but I think some of these cases show why this role has to be undertaken with a fair amount of caution and sensitivity. And I don't know that there are any great easy answers, but I think understanding the trend is a good place to start. Thanks.
Well, thank you very much, Ashley. Actually, I think the phrase "trump the European court" has a certain ring to it. So Dale has been embedded in academia for the last year, and he tells me that this may influence his presentation somewhat, so I'm looking forward to it. So Dale, the floor is yours.
Thank you. Thank you very much, David. Let me just indulge myself briefly by indulge you by acknowledging two people in this audience. I was in Iraq in 2008. I had the honour of serving with Colonel Ren Gady and Commander Joe Baveri. If coalition operations are intended to rely upon mutual respect and trust, effective communication and genuine teamwork to achieve objectives, then these two fine officers are high ambassadors of that cause. Secondly, Dennis, I know you, at the beginning you gave an all-encompassing non-attribution, we don't speak for our governments, but for the Australian Senate inquiry that will use the video of this of me, let me say I speak for myself. It's not the Australian government or the RAN or anyone else. This is my concoction. I'm going to talk about theory. The last presentation on the second day, look at Mike Schmidt, and you're trapped. You're trapped. You had the opportunity at the coffee break to escape and you didn't. So if we could have the video, the slides, please. Lawfare in asymmetrical conflicts. We live in an age of lawfare, perhaps we always have. Charlie Dunlap, General Dunlap spoke about his definition, no fixed definition, but generically understood to be the use or misuse of law as a substitute for traditional military means to achieve military objectives. I like Ryan's comment that authors have no authority to interpret what they said, so I will interpret what you said, sir. How is lawfare manifested? There's various trajectories. We've seen domestic US legal litigation, and the Lawfare project accounts for that. We've seen transnational incidents where NGOs, international NGOs, will bring domestic litigation, and of course we have public international law, the law of armed conflict, and that is what I'm going to be speaking about. Lawfare has been attacked as a refuge of the weak, but I share General Dunlap's view. Lawfare, I don't think, is intrinsically good or bad. It just is. What it does do, to me at least, it highlights a certain lens of inquiry about law's role and its sense of its role in what we do against a political and social context. And I believe it implicates legal interpretive theory that I do want to just dwell on. We've seen a burgeoning interest in the law of armed conflict at universities around the world. I audited a class up in Boston that was heavily oversubscribed. And that, I think, is a common feature in universities around the world today in the law of armed conflict. And that has generated a line of scholarship, certainly this century, that seeks to address the law of armed conflict in its social and political context. One author, Nathaniel Berman, has written, I think, a fairly interesting article that talks about LOAC itself being a product of construction, contestation and strategic instrumentalisation. He makes the comment, or comes to the conclusion, that I don't think is revolutionary, really, that the law of armed conflict favours state military forces. I think that's rather self-evident. States make international law and they make the law of armed conflict, and that is I believe that's a necessary consequence. He talks about combatant immunities and POW status for military forces. He looks at AP2 and says even in those circumstances, rebel forces need to have state-like indicia or criteria to be recognised as, certainly for the purposes of AP2. We see in the law of naval warfare, not only do state military forces have an advantage, but stronger state military forces have a particular advantage when we look at, for example, the requirement of effectiveness in blockades, both naval and aerial, and similarly in visit and search, where you have an unlimited geographic arena. Those countries with more robust naval and air forces are going to exercise those rights more broadly, a use of the law to achieve a military aim. Law is, in fact, routinely, I say, invoked by states as a substitute for obtaining military ends. All necessary means, Chapter 7, Security Council resolution, displaces the law of neutrality, and that achieves quite a significant military advantage. A determination of whether you have an armed conflict and the type of armed conflict also carries obvious military consequences, and detainee status and detainee rights, which we've been talking about, similarly has that effect. Ironically, given that General Dunlap wrote his article in 2001, lawfare was actually alleged to be something that state military forces did in the 1990s in relying upon the law of armed conflict. So it's an interesting turn this century that it's now used in a negative way. Now let me focus on that negative way. I've been trying to analyse what is it that's troubling, and how does that relate to the issue of interpretation. Rivkin and Casey wrote an interesting article in the New York Times, I think it was. And they say it as you see up on the screen there. The term lawfare describes the growing use of international law claims, usually factually or legally meritless, as a tool of war. The goal is to gain a moral advantage over your enemy in the court of world public opinion, and potentially a legal advantage in national and international tribunals. I want to just focus on the moral advantage and the political advantage, because I think that's a significant claim about the role of lawfare vis-a-vis military forces. When I tried to find examples of that, beyond just allegations of, just incorrect allegations of war crime violations, but what are the tactics of lawfare? An interesting article by Talbot Jensen, an army JAG, I think, and he wrote, he listed, this is how non-state forces might use the law to achieve these political and moral aims. And you see the list there, attacking from protected places, using them as weapons storage sites, etc., etc. What struck me about that is that these examples, of course, can be overcome as a matter of positive law. There's no immunity. You can attack these places when they are converted for these uses. The question that we deal with in lawfare is the political and moral impact of that for the continuation of operations. And that implicates, I say, formalism or positivism, and I know there are debates about those very terms, but I'm going to just lump them together. Formalism, which is our dominant interpretive idiom for the law of armed conflict, it's what we have been doing for the last 2 days, is seen by some as old-fashioned, as a bit stodgy, but in fact, at the turn of the century, it was regarded as very progressive, and in that it reduced naturalist conceptions and sovereign prerogatives regarding the law of war to a written record of what you may or may not do according to certain rules. And in fact, if you read authors from the 1920s and the 1930s, there's this palpable excitement about what codification of the law of armed conflict is going to do. It's quite palpable when you read. So what are the features of positivism? Why am I dwelling on this? Because I think positivism exposes certain vulnerabilities to lawfare, to allegations of lawfare, and I think we need to be aware of that. What are these features of positivism that I talk about? I'm drawing on the famous HLA Hart view of positivism. There are various views all over the place, but his, of course, is one that's recognised by most as being somewhere in the middle, perhaps. And in that view, words, in his mind, under positivism, do most of the work. And indeed, as I recall what we've been doing over the last couple of days, we've been passing words, the emphasis on or today, Mike Schmidt's comment about military attacks versus attacks. Words do most of the work in positivist analysis. And Hart had a theory about core and penumbra. I don't want to make this law theory 101, but he had a view that the majority of the law of interpretation was rather settled, that words in the core, which he regarded as quite large, had determinate meaning and gave certain direction. He acknowledged a small penumbra where you could imply a more liberal sort of discretion of interpretation, but the core was rather large. Importantly for positivism, there was no necessary relationship between legal validity and morality, a point that we've been dancing around over the last couple of days. For legal validity, you don't look, as Aquinas did, to divine guidance. You rather look at social facts. And those social facts form in Hart's primary and secondary rules, primary rules of obligation, secondary rules of change, adjudication, and most importantly, rules of recognition, all based on social fact, not the power of the king and not morality. And what held this all together was the inner perspective by laws officials, not out there in the world, but just laws officials. Why am I saying all this? What's the importance of this? Well, I think it implicates what we do and gives certain, as I said, vulnerabilities to allegations of lawfare. Justice Higgins, in a famous exchange in 1972, I think it was, between her and Oscar Schachter, presented a view of international law that she actually said was a more or less British view. Oscar Schachter presented an American view, and she was quite assertive in saying the law is the application of neutral rules to obtain predictable results. That concept has been subject to considerable critique, both in UK and more prominently in the United States. Dworkin, Fuller, the entire American realist tradition, Duncan Kennedy, and all the crazy critical legal studies people all have critiqued that notion of the certainty and the determinacy of law. And I think when we look at that, when we see the malleability of language and how open it is, I come to the conclusion that the core is a little smaller than what certainly H.L.A. Hart would say. And I just followed the debate, for example, of the application of Common Article 3 to Afghanistan. And when you read the literature, the reports that came out about that, I was struck. I'm not concerned so much with the substance, but the structure was it all relied upon textual analysis. You had you and Bybee talking about textual analysis, that it being precise language was not used, that could have been, and hence it didn't apply. You had William Tarr from the State Department saying, well, the plain language of these conventions says otherwise. You have the US Supreme Court saying that the phrase is not of an international character, bears its literal meaning. A debate all about plain words, literal meaning, which is the core, excuse the pun, the core basis of what is in the core of Hart's analysis. So what does that mean? What does this mean in terms of where we go? Positivism is non-directive. Unlike Dworkin's view, there's no right answer. You go where the words take you. What positivists say, though, is that, and this is, again, an issue we've been dancing around, moral advantage and public opinion are separate to law. And that has consequences for what we do in our interpretation in the context of lawfare. I think we have choices. We can hunker down, and in conferences such as this, I see as an exercise in trying to fill out the core with certainty. So we have certain meanings of the law of armed conflict, and we hunker down to moral and political critique as being something altogether separate. But I think that that's certainly one option. But I think another option is to perhaps look into this a little further. Jack Goldsmith has says that we as lawyers suffer what he calls a methodological unsophistication. Law, when it gets into the realm of international relations, we don't seem to look over that fence. We don't look at what happens when law gets mobilised by political, for political ends. We don't query cause and effect when that happens. And there's been a whole line of cases about law and social agency and political mobilisation that I think we should, as lawyers, be aware of. And there's particularly two books, one by Margaret Catherine Sinkink, Beth Simmons, that actually is a how-to guide. How do we use the law to mobilise political constituencies to achieve political effects? Now, for certain audiences, that's irrelevant. The law is the law is the law, and we stick to it. But in a liberal democratic society where militaries operate pursuant to government direction, that has an effect, in reality, in the field. And I think it's important to try and understand those effects when dealing with lawfare as a sort of counter lawfare. And I won't go into the details of what they're saying, but one of the issues is framing, which I found quite interesting. They looked at Keck and Sinkink looked at the issue of the Anti-Personnel Landmines Convention. Initially, it was sold as an issue about military utility, protection of forces. The mobilisation process said no. Let's frame it into indiscriminate killing. And once that happened, once that step of framing it as that issue happened, suddenly there was an avalanche of political reaction which resulted in the Ottawa Convention, according to these authors. I just found that a very interesting technique on lawfare, which might inform a counter-strategy to lawfare. If law, then, just stepping out from the safe moorings of positivism, if law is in fact a rhetorical strategy, if war is law by other means, then we can look at some of the other authors. And David Kennedy has written an interesting account. In the court of world public opinion, the laws in force are not necessarily the rules that are valid in some technical sense, but the rules that are persuasive to relevant political constituencies. And you can read the rest. He talks about law, I think, in this penumbral region, at least, as being open to greater debate and greater interpretation based on reactions from relevant, what he calls constituencies with relevant political clout. What are those constituencies? Well, interpretive communities, the invisible college, as Oscar Schachter spoke about it, international audiences, domestic audiences, coalition partners, NGOs, political elites, media. I think military lawyers, quite frankly, when operating in the penumbral region, according to Hart at least, do indeed take into account these sorts of considerations. But I want to be very careful about this, because at this point, when I say this, there's been a series of blogs about what I've said, and I need to be very careful. I'm not saying that lawyers step outside of the law and start predicting political reaction in their interpretations. Rather, I say that the law is more indeterminate than what I think we might want it to be. And in that space, in that indeterminate space, we have to fill gaps. We have to make decisions. And I think positivism, with its separation thesis, I think has certain consequences. So I think what we're doing is we often grappling with indeterminacy and contradictions. Legal advice, in my mind, rarely deals with unlawful and lawful. It's been very rare that I ever deal with that. Rather, when you give advice as a lawyer in the field to commanders, it's variations of lawful, from colourable arguments to reasonable arguments to persuasive arguments to slam dunk arguments under the law. And in those spaces when we are in the penumbra, how do we fill those spaces? And I think what David Kennedy is saying here, I think has some resonance. And I think we rely on, in my mind, on legal principles. We've heard the term used the last couple of days. And Oscar Schachter made quite a statement about legal principles. They're like confetti out there, and they act in opposition. He spoke about military necessity, the principle of humanity, obviously, sovereign coastal rights, sovereignty, freedom of navigation, self-determination, self-defence. They all operate in opposition, and you make choices in that indeterminate area, and you invoke those principles to give effect to your legal opinion. I've got up there a quote by Georgiev in response to Marty Koskieni's view that the law, international law, is either utopian or an apology. He says, no, it's not. But in those open spaces, we do deal with a sort of politics of the law. It's what we do. Interestingly, in that exchange between Schachter and Higgins denied that. Oscar Schachter said that's exactly what we do, and I do believe that we do it. So what are legal principles? What are the things that fill the gaps? And this is where I think we look at Article 38(1)(c), General Principles of Law recognised by civilised nations, and Cal Chauvin talks about principles deriving from principles of morality. They derive an inner force from their morality. Take it, we'll leave it there. It's an account by Cal Chauvin that I think has some persuasive weight, and he's analysed cases to say this is not customary international law, this is actually, they're implying legal principles. Dworkin had a similar type concept with regards to political morality as directing an outcome, filling those gaps in the penumbral regions, if you like. Is the separation thesis overstated? I think a little bit myself, certainly through the means of Article 38(1)(c) and the application of principles to the determination of outcomes. I just want to tack gears a little bit to look very briefly at what might be called inner lawfare within the military. And in my reading, I came across a very interesting article by Michael Hatfield that tried to explain the so-called torture memos and what drove those memos to be written. And he looked at the role of military lawyers in that, senior JAGs who resisted some of those opinions. And he came to the conclusion, and I quote it here, military lawyers deferred to the law as an accumulation of hard-won institutional wisdom. They believed the law against torture to be a reality-based warning to keep us from being doomed to learn the same lessons, usually referred to as those from Vietnam again and again. And I see the reference to Vietnam frequently in a lot of the literature about this, and I have a sense that the literature acknowledges that something was lost, something intangible was lost through the Vietnam era, and certainly the US military, and I'd suggest the Australian military, who also fought in Vietnam, have been seeking to to restore something this intangible thing that was lost. Is it means ends rationality? Perhaps, and some authors have spoken about it, or is it something else? Value rationality in your attitude, your initial attitude to interpretation. And I just want to briefly look at the concept of virtue ethics that Mark Osiel from the University of Iowa has written about. He's written I believe, a very interesting account, The End of Reciprocity. It talks about virtue ethics as guiding senior JAG, US JAG resistance to some of the legal opinions that were coming out of the Bush administration. What are virtue ethics? He says it's a reversion to an aristocratic type allegiance to ethical virtues. Virtue becomes an end in itself. One strives not to live in conscious accordance with abstract principles applicable to all, but to model oneself on heroic archetypes of one's profession. The JAG corps are our epistemic community. The duties we owe to those we have detained as terrorist suspects should best be understood as an inference from the duties we owe our fellow citizens to behave honourably, consistent with our identity as people constituently committed to the rule of law. And we have that. When I raise this in audiences, in mixed audience, I always have an interesting reaction. Non-military people see this as a little bit corny. Military people seem to react immediately to this concept, and I wonder if there's not a sociology aspect to this. But we see this in terms of codes of honour, as Osiel talks about. Simple heuristic devices, Marines don't do that. Says it all. Similarly, it's not about them, it's about us, which was an opening line to some of the litigation. Not a discourse in human rights, not a discourse in means, ends, rationality and construction, but something deeper and has been alleged, something stronger to help frame approaches to legal interpretation. It does, of course, the issue does, of course, and Jack Goldsmith is in fact going to be writing a book about this, it does bring into tension primacy to the civil authority, which is fundamental and profound, and restoration and maintenance of a professional ethos. And it's a conflicting concept that orients our approach. And I just raised that. I don't know if there is an answer, but I raised that. Very quickly, let me just also talk about COIN. COIN represents to me another version of another interpretive idiom, one that I think very classically reflects an older style American legal realist orientation. Sarah Sewell from the Kennedy School wrote in the beginning of the book, those who fail to see the manual as radical probably don't understand it, or at least don't understand what it's up against. And I think it says some very interesting things. And what it says, not only just sort of talking about Afghanistan, I'm coming to the conclusion that perhaps it isn't a cover-all. It certainly had an effect in Iraq when we were there. And I had operators starting to look at the use of force in instrumental terms, starting to look at the application of force in terms of effect, and relying on certain social scientific analyses to try and understand what that effect was going to be. And that's represented in the book. Now, the manual, the doctrine, does talk about legal interpretation and does have an orientation. It talks about distinction and proportionality. And I just raise this as an alternative perhaps to a standard positivist approach, just to see what it reveals. Whether you accept it or not is up to you, but it's just interesting. I find we did, of course, cover this last year at last year's conference, but I just want to revisit it a little bit in terms of lawfare. Insurgency, fundamentally a political struggle. What I find interesting that Kilcullen says is that what insurgents want counterinsurgents, i.e. us, to do is to transgress our ethics and morals and overreach and overreact. That is their goal. Accordingly, we had in Iraq at least MNFI guidelines. I'm reproducing them because they're out there in the public domain. This particular statement endorsed by General Petraeus: we cannot kill our way out of this endeavour. We and our Iraqi partners must identify and separate the reconcilables from the irreconcilables. We must strive to make reconcilables part of the solution. And that impacted upon decisions as to discrimination and certainly targeting. Very quickly, wrapping up, COIN, the principle of proportionality, what the COIN manual says in this context, killing, and we've covered this a little bit, killing the civilian is no longer just collateral damage. The harm cannot be easily dismissed as unintended. Civilian casualties tangibly undermine the counterinsurgents' goals. The fact or perception of civilian deaths by their nominal protectors can change popular attitudes from neutrality to anger and active opposition. It does look in terms of social and political alienation of consequence of collateral damage, but it's certainly an instrumentalisation of the law, and through a sort of conflation of humanitarianism with military advantage. So, concluding thoughts. What are my concluding thoughts? Lawfare implicates interpretive theory, frankly. We exist in the positivist dominant idiom, and that has certain consequences, and we might hunker down and stay with it, which I imagine we will, try and expand the core, and our answer to allegations of moral or political reaction is, well, it's the law, the end. And that's a point we've been discussing, and that may be effective. It may be effective, but we might want other alternatives. We might want to understand the role of law in political mobilisation, and we might want to prepare for that in terms of reaction. War is law by other means. The conduct of contemporary military operations takes place, I'd submit, in highly complex contested terrain of social and legal norms. It is about construction, contestation and instrumentalisation, and I think we do have an opportunity for counter lawfare. So what do I conclude with? This is my touchstone, quoting Yoram Dinstein, which I actually think is a very good touchstone. Every single norm of the law of international armed conflict is moulded by a parallelogram of forces. It confronts a built-in tension between the relentless demands of military necessity and humanitarian considerations. Working out a compromise formula, it can be stated categorically that no part of the law of international armed conflict overlooks military requirements, just as no part of the law of international armed conflict loses sight of humanitarian considerations. I think that's, for me at least, a touchstone for any interpretation under any filter that I should apply. What is the role of lawyers of all of this? Well, that's what my doctoral thesis is going to explore, so that'll be part 2 of all this. But I do think there is a role for virtual ethics. I do think means ends rationality applies. I think there is an instrumentalisation of the law, and that does generate tensions and potential conflicts between civil primacy and professional ethos. Thank you.
Okay, Dale, thank you. We have approached this subject from a number of different angles across the spectrum, if you will. I am going to assume that none of the panel members have violent disagreement with anything else that any of the other panel members have said, but I will offer you the opportunity to make one comment.
Stop me before I press that button. Just
one comment, Charles.
I do have to take issue with Dale's discussion of the coin. I think the coin manual has been very destructive to the Air Force and actually to the success of counterinsurgency. Steve Call wrote a column about it. He says, you know, it's law for Northeast, or it's strategy for Northeast graduate students, the kind of people who would never own a gun. It's this faux presentation of what counterinsurgency is. And when the history is written, in most of history, successful counterinsurgency has been, you've killed and captured your way out of it. And I think it's disingenuous when people present the success in Iraq in 2007 as anything other than that, because we all know that the success occurred when the number of young Iraqi males that were incarcerated was nearly tripled. And, you know, that's the Boer War model. And the number of Iraqis killed went up dramatically. The number of airstrikes in that 2007 period was fivefold what it was the previous year. So the idea that somehow violence isn't involved is wrong, and it's created this perception, which I think is part of the problem that we have now in Afghanistan. People think that if it's done right, there is no violence, people don't get killed, you dig a well, and everybody's happy. And it's created this expectation in the public, which is why the support for the operation in the U.S. public and European publics is declining, because they're seeing people getting killed on both sides.
Can I just respond to that? Sure, I don't... my sense of it is that throughout, certainly my time in Iraq, there was no doubt that the bad guys still got targeted and you hit them hard. But the notion that any DPH finding resulted in targeting was something that became more nuanced. And the whole, my sense of it is the whole Sons of Iraq transfer was partly responsible to a changed attitude to targeting people who, some of whom, still had arrest warrants out for their arrest, which weren't executed.
Okay, time out, guys. Okay. Questions? Mike, you want to start off? Is this a case of German technology? I don't...
this is a mechanical problem.
This question is for Pnina. I thought your presentation was, as always, interesting, Pnina. But I have to tell you, it was, for an American, it was hard to grasp because, particularly with regard to warnings, the extent to which the Israelis took care to warn goes so far beyond the law, it's almost unimaginable. I mean, Article 57 of the protocol, customary law requires effective warnings, and you've not only done that, you've gone even beyond all feasible warnings. You've done all possible, imaginable, theoretical warnings. I mean, it's just quite extraordinary. Yet at the same time, the Goldstone report beats the Israelis up for failures to warn. Yes, you made a phone call to the person 15 minutes before you attacked, but you didn't give them directions where to go. You didn't activate Google Map and send them to some place. So what I'm trying to figure out in light of the debate between Dale and Charlie is what goes on, and this is a decision-making question. How does Israeli decision-making work? Where do you fall down on this coin concept? Why are you trying so hard to avoid civilian casualties when they're going to, the UN is going to beat you every time, and every human rights organization? So could you give us a sense of what the discussions are like? Has people propose and you debate these sorts of precautions in attack and so forth? Another example, human shields. I know you have a policy on human shields. Another example, children in armed conflict. I know you have a very restrictive policy on children in armed conflict. So give us a sense as non-Israelis of the type of discussions that go on, the type of logic that goes
on. Well, I think, and here I think I agree that, or at least the way it works in Israel, is that the law is maybe a starting point, but it's not the only consideration. And the idea in the operations where Israel is involved is really to reach the minimal number, preferably no civilian casualties, not just as a matter of law, but also as a matter of, well, there's also, of course, the moral issues, but I think what underlies here is more the anticipation of the reactions to civilian casualties. And we know that Israel does not, or is not accorded any level even of allowing it any kind of any casualty, any damage is immediately translated with regard to Israel to criticism, to pressure. Also from within, we have a lot of internal also NGOs and a lot of organizations within Israel, and we have a Supreme Court that is very involved even in operational decisions. So we have the internal level, but also the external pressure that immediately starts in the Second Lebanon War after an incident in the Kana village, where many civilians were killed, they stopped the operation for 2 days that were critical. 2 days. And it was an object that was approved. There was a military advantage in the attack. It went through all the levels of authorization, but civilians were killed. And it doesn't really matter if they were killed, if it was a lawful attack. The result was still that we have to stop our activities for 2 days. And now, the Goldstone report is another step, or I think it's really, for Israel, goes beyond all the criticism we are used to getting in really its bottom line. And I think as a legal advisor in the military, it will be more difficult today to come to the commanders and say, look, these are the limitations, because the Israeli commanders are, and I think you alluded to that, saying, why should we bother? I mean, it really doesn't matter. Whatever we do, in the end, they will say that we are war criminals. I'm deemed a war criminal by some organizations and their websites. So I still think that we cannot, give in and say, okay, so let's just disregard the rules. And we still are obliged by the rules, and I think still have to act in a very limiting way, even above and beyond what the rules require, because of the strategic situation we have in Israel, we face in Israel.
I think everyone has to agree that the Israelis are in a very unique situation. I think what we all have to be concerned about is simply because they have taken the precautions that they have taken and adapted the operational approach they've adapted, that doesn't become the gold standard, that doesn't become the expectation of the international community, and that's one of the points that we wanted to drive home today. Harvey?
First, thank you. I think it was a very, very thoughtful and wonderful panel that was put together. The question I'm going to pose is maybe get the panel all together, which is that the debate that Charlie put forward on focusing on the ROE, there was sort of a consensus that the ROE is the law for the use of the force, but it ultimately is a policy decision. It's not a legal decision. It's a policy decision by the commander. And then Dale's sort of argument that law is really the clever use of misquoting Clausewitz, that in the end, it's about the policy issue. And these are all instruments of policy. And the concern of the panel that in the Israeli situation that somehow some practice will become a one-way ratchet, that once you go above that base that's considered in the law of armed conflict, that you create an expectation inside the system. But Ashley's argument, which is I think sort of the notion of lawfare, is there's a wild card in the process. And the wild card is our Supreme Court, the UK courts, and what's conspicuous by its absence are the Israeli courts. The Israeli courts have been commenting and creating both domestically, which have been highly criticized by people inside Israel. They've gone too far vis-a-vis ranges of issues of targeted killing and Baruch's position. So I want to engage the panel, which is that given your positions, these individual domestic courts are becoming very, very powerful in setting the expectations and the real black letter law for what's happening in detention, or whether or not you're going to tolerate the prosecution, whether the court asserts executive privilege, whether the court decides to decline it. This is becoming a huge phenomena inside the modern twilight warfare that we're dealing with. And I'm curious to see the panel across the way as to how they understand this sort of new element that's involved in the process.
Okay, ladies and gentlemen, can you do that in 2 sentences or less as we go through the panel? Charlie, why don't you start?
I think, at least from the U.S. perspective, you will not see the courts getting involved in targeting decisions under any circumstances, virtually. Detention and everything else, that's a habeas, that's a whole nother animal. And the court was even reluctant to do that. And I think there's very peculiar circumstances that drove them to it. And part of it was the notion that the executive could have this law-free total discretion drove the court to take action it really didn't want to take. But they will not get, I don't see any indication that they'll get into second-guessing true use in bello type questions.
Ashley?
I guess, given my thesis, which is that U.S. courts have been far more reluctant to engage, I tend to agree with that. And also, you can look at the Bankovich case, which was the European court itself saying, well, here's a targeting case before us. We're not finding jurisdiction over that. And I think there's also been a case in Germany where there was a challenge brought by some victims of a bombing. There may be a more recent one. I don't know the outcome of that. But there was, I think, one from a couple years ago where the German court said, we're not going to either. I don't know if they reached the merits or jurisdiction, but one question is whether that is the next wave and there will be some break in the wall in some domestic court, but I certainly don't think it will start in the U.S., and I'm skeptical that, for example, a UK court would approach that.
Pnina?
Well, in Israel, we are used to the courts being involved in any case, including in operation cases, including we have court cases about the use of flechette, about the target killings, about use of certain weapons. During and amidst the conflicts in Operation Costlet, there was a case with regard to the entry of supplies. We asked the court to issue just a statement by the head of the civil liaison commander because he was busy in the operation, and the court declined and said no, he has to come here in person, so we had to get him there and explain to the court in detail what is being done. And so we're used to it already, so it seems to us natural, but we have a very active court, and it forces us to be, and the court also checks everything according to international law. So it deems that we have to be involved, and the commanders have to come and explain, and we have to explain the law even during operations. Yeah.
And
targeting too, yes, everything. No exceptions.
There's no tradition in Australia that I know of. I mean, I've got the expert up there on discipline law, but we haven't had any litigation in Australian courts about Australian violations of the law of armed conflict that I know of. However, we signed and ratified the ICC statute. It's now part of Commonwealth law. The smiled irony of that is the American participation in the proceedings gave quite a bit of license under that treaty, and the defences that it gave some broad discretion, in my mind. So when we draft rules of engagement, we have one of the factors is the ICC statute as enacted into Australian law, and I'm just surprised at some of the breadth in some of the provisions. So.
we have time for one more question. Yeah.
It's a comment in relation to Ashley's analysis of the cases, and it fits the last issue that was raised. I think there is a specific explanation for what's happened in the Binyamin Mohammed litigation, and that's that the government kept lying to the court. They kept saying they'd produced all the documents when they hadn't. They said that it was caused by one thing when there was another reason for it, and the court got really hacked off with that attitude on the part of the government. I think your point about making sure cases are pleaded well is hugely important, particularly in the European Court of Human Rights. The other key thing at the English level that's made a difference, you're right, is the Human Rights Act. At the Strasbourg level, if European states want to detain, then all they need to do is derogate. It is absolutely unequivocally clear from existing case law that if you derogate, then you can have administrative detention or internment. There is a question as to whether you can derogate when it's another state's emergency, but I'm sure that Strasbourg there would be pragmatic. The problem is states aren't derogating, so they can't complain. On Al-Skani, most of the cases as part of the Al-Skani package don't involve detention, but involve killings, and there's the issue of extraterritoriality, so Bankovich will be revisited there. One area where Bankovich will definitely be revisited is all the Georgia-Russia litigation. There's an interstate case, and there's hundreds of individual cases, both brought by Russians against Georgia and Georgians against Russia. So a lot of these questions, including extraterritoriality with regards to killings, will come up because the attack on Gori is one of the issues that's been raised.
Okay, ladies and gentlemen, I think the issue of whether a change, a shift in how the law of armed conflict is being interpreted in various fora is an exceptionally important issue, and one that we've just begun to scratch the surface. But I think the only thing that we have remaining to do today is to thank our panelists for their excellent presentations.